I'm Ted Tao, a district court judge in Adams County, the 17th Judicial District. I'm going to talk briefly about the right to bail and pretrial release. The right to bail is secured by the Colorado Constitution in two separate sections. Article 2, Section 20 prohibits excessive bail. Article 2, Section 19 provides that all persons are bailable by sufficient sureties, except in certain enumerated situations. The constitutional language is essentially then incorporated into statute in CRS 16.4.101. The exceptions are first, capital cases, where the proof is evident or the presumption of guilt is great. And second, non-capital crimes of violence committed while on probation or parole for a previous crime of violence, while on bail pending disposition of a previous crime of violence, after two previous felony convictions or one previous felony crime of violence conviction. In non-capital cases, where the people seek to prevent bail, there must be a hearing within 96 hours with reasonable notice to the defense, after which the court finds proof evident or presumption great and finds that the public would be placed in significant peril if the accused were to be released. If bail is denied in a non-capital case, trial must take place within 91 days, and if not, and if the delay is not attributable to the defendant, the court must immediately set a bail hearing and set bail. Interestingly, the statute adds two types of offenses to the list of non-capital offenses for which bail can be denied that are not included in the constitutional provision: possession of a weapon by a previous offender and sexual assaults. Whether denying bail in such cases would pass constitutional muster is as yet an unresolved question. For all other cases, bond will initially be set in one of two ways. If law enforcement has sought an arrest warrant, bond will be set at the time the warrant is approved. If, on the other hand, the accused is arrested without a warrant, bond will be set at the first appearance. Significantly, Section 16.4.103, subparagraph 2, provides that even where the bond is already fixed in the warrant, the advising court shall review bond at the first appearance after arrest. Section 16.4.103 sets forth the purposes of bond and the factors you must consider. The purpose of bond is twofold: to reasonably ensure the appearance of the person as required in court, and to protect the safety of any person in the community. The statute requires the use, if practicable and available in your jurisdiction, of an empirically developed risk assessment tool designed to improve pretrial release decisions. In the wake of that legislative mandate, the judicial branch has developed the Colorado Pretrial Assessment Tool, or CPAT. If you have a pretrial services agency, they will use the CPAT to help guide your decision in setting bond. I will not attempt here to get into the weeds of how CPAT works, but in a nutshell, it combines an interview of the individual with a review of his criminal records to inquire into several factors that touch on stability, financial status, and historical success under supervision. The interview is done by your pretrial services agency if you have one. The pretrial services agency uses the results of that inquiry to derive a risk category between 1 and 4, with 1 reflecting a low risk and 4 being a high risk. Your pretrial services agency will report to you the risk category for that particular defendant. Your chief judge may also have established a bond schedule, which will set a presumptive bond based on the type of crime. If you have a bond schedule, use the risk factor from the CPAT to determine whether the bond should be set above or below that scheduled amount. In some districts, the bond schedule is also used as a presumptive setting, so individuals may post bail before seeing a judge. Remember, however, that even if this has happened, you will still address bail at the initial appearance using the CPAT score if you have one. In setting the amount of bond, if you do not have a CPAT report, you should consider the same factors that CPAT takes into account. Things like employment status and history, the nature and extent of family relationships, residential stability, whether there is someone who is willing to assist the accused in showing up to court, the potential sentence for the crime charged, prior criminal history including past success or failure on bond, probation, or parole, any facts indicating the possibility of future law violations, and any facts suggesting a potential for victim or witness harassment. You should take care to avoid setting bond in a way that leads to unnecessary incarceration or over-supervision in the community, which may actually increase the risk of reoffense. You will also need to set the type of bond. This is typically a surety bond where the accused pays a premium, usually between 10 and 20% of the bond amount, to a professional bonding agent. But other types of bonds are available. You could, for example, set a cash bond or a property bond where the bond is secured by a lien on real property. Property bonds should generally be avoided, in part because they impose a significant additional administrative burden on court staff from the additional paperwork needed and the increased effort to collect in the event of forfeiture. Another possibility is a personal recognizance or PR bond. With a PR bond, the accused does not have to pay any money up front, but if he or she fails to appear in court, the revocation of the PR bond would also entail the entry of a judgment against the accused in the amount of the bond. If your jurisdiction has a pretrial release program, you can impose supervision requirements on the PR bond. The most common thing to do is to provide that the bond be cash or surety, but in the right case, you might even consider splitting the bond, requiring a lower surety bond and adding a secondary component of a PR bond with or without pretrial supervision. In addition to setting an amount and type of bond, you must also determine what conditions will be imposed as part of the bond. Section 16.4.105 discusses bond conditions. Some are automatic and apply to every bond, such as not committing any new felony while on bond. Further, a bond on a felony charge must include a condition that the accused sign a waiver of extradition. If the charge involves domestic violence, stalking, or unlawful sexual behavior, the bond must require the accused to acknowledge the automatic protection order put in place by CRS 18-1-1001. If the charge is a DUI and the accused has a prior alcohol offense, the bond must impose monitored sobriety conditions. Be aware that some actions you take concerning bond will implicate the rights of the victim if the charge falls under the Victims' Rights Act. Once bond is set, any changes to the bond that reduce the amount of bond, alter the type of bond, or modify a condition of bond are critical stages that require notice to the victim and an opportunity to be heard. One caveat: sometimes a person is arrested under suspicion of committing one crime, but upon return of the filing, the prosecution has filed a different crime. For example, a person is arrested for second-degree assault and bond is set accordingly, but the ultimate filing is only for third-degree assault. On the return date for the filing of charges, you will likely reset the bond consistent with the misdemeanor charge. Although this is by definition lowering the bond, it is not a critical stage under the Victims' Rights Act. The statute specifically states that the setting of a new bond upon the filing of charges is not a bond modification, provided the new bond is consistent with the scheduled or customary amount for the charge actually filed. If the accused is on bond and does not appear for court or otherwise violates a condition of his bond, you have the power to revoke the bond. However, failing to appear is the only bond violation for which forfeiture of the bond may be ordered. If the accused does fail to appear, you should revoke the bond, issue a bench warrant, and set a new bond in some amount higher than previously set. For example, in Adams County, we often double the previous bond. With the assistance of the CPAT or your own consideration of the statutory factors, and a little bit of luck, your decision will ensure that the accused appears in court and that the matter can be resolved without unnecessary delay. Good luck.